Good morning, everyone. Welcome to this webinar on litigating on statelessness, the right to respect for private and family life. We are holding this webinar ahead of the publication of a new legal briefing on statelessness and the right to respect for private and family life this week, which we prepared in partnership with the AIR Center. Today, we will have a discussion about statelessness and the right to respect for private and family life. I am joined by three wonderful speakers, which I will introduce in just a moment. So this webinar will last 1 hour. I very much hope that we will have a few minutes at the end to take any questions from the audience. And in the meantime, and throughout this discussion, please feel free to post your questions in the chat, and we will try to pick them up either throughout our discussion or at the end of the webinar. My colleague Cameron is monitoring the chat and will post any useful links and answer some of your questions. So before delving into today's topic, I wanted to provide an introduction on the European Network on Statelessness, so ENS. Our work, and specifically our work on litigation. So ENS is a civil society alliance working to protect stateless people and promote the right to a nationality in Europe. We have over 180 members in 41 countries. Our members include non-governmental organizations, lawyers, academics, experts, community organizations, and activists. We have partnerships with UNHCR, OSCE, the EU, the Council of Europe, and others. Our activities focus on law and policy development, including strategic litigation, as well as capacity building and awareness raising. And we work on 4 thematic priorities, which are forced migration, childhood statelessness, access to justice, and anti-discrimination. As many of you, I'm sure, we see litigation as a powerful tool to address injustice and tackle those policy and practices that fail to protect stateless people. So with that in mind, in 2021, we launched the first ever statelessness case law database. It contains summaries of judgments on statelessness from national, European, and international courts. And since then, we have drawn on it to produce valuable practical tools for litigators, such as our recently updated litigation toolkit on statelessness. And we delivered several training sessions for our members and partners specifically designed to litigate on statelessness. To address critical gaps in knowledge preventing statelessness from being addressed through the courts, we have published comparative legal analysis on key international legal principles to help inform and strengthen litigation at national level. A recent example is our legal briefing on the principle on non-discrimination and its impact on the prevention and reduction of statelessness among Romani communities in Europe. You can find links to the resources I mentioned in the chat. Some progress has been made thanks to persistence and collective strength, and you'll see examples of that progress in the new briefing we're publishing. But there are still a lot of opportunities for the courts to keep pushing for change, and we seize opportunities to intervene in cases before courts, including recently we intervened in cases on family reunification and birth registration before. You can follow our litigation activities on our website as well as on our litigation bulletins, which also demonstrate the litigation work of, from our members across Europe. So, recognizing the role that the courts play in developing and effectively implementing the right to a nationality and the human rights of stateless people, our new legal briefing outlines how statelessness interferes with the right to respect for private and family life, and how the courts can uphold that right. So to protect stateless people, to implement effective and accessible routes to regularization, to promote birth registration, and prevent the arbitrary denial of nationality. The briefing draws on the international and regional legal framework, as well as jurisprudence from the European Court of Human Rights and the Court of Justice of the European Union, to set out the positive obligation that states have to protect stateless people, to uphold children's right to a nationality and birth registration, implement effective and accessible routes to regularization, and prevent the arbitrary denial of nationality. Let me now introduce our speakers. So we have today with us Nuala Moll, who's founder and senior lawyer at the Air Center. Nuala Moll founded the Air Center in 1993 to provide information and advice on European law and representation when needed before the European Court of Human Rights. She has been involved as an applicant's representative or a third-party intervener in over 150 cases before the European Court of Human Rights and the Court of Justice of the European Union, as well as participating in intergovernmental discussions to improve European human rights standards and compliance with them. We also have Dr. Kaya Vliegs. Dr. Kaya Vliegs is Assistant Professor of Constitutional Law at Utrecht University in the Netherlands, and she's connected to the Montaigne Center for Rule of Law and Administration of Justice. She has over 10 years of learned experience in legal research and teaching on statelessness with a focus on European and fundamental rights law. We also have with us a member of ENS with lived experience of statelessness who will remain anonymous. To kick off our discussion, Kaya, I was wondering if you could share with us what the jurisprudential evolution of the right to respect for private and family life has been and how it could be used to litigate on statelessness.
Many thanks for that introduction, Alexia, and thank you so much for having me during this webinar to launch this briefing, which I think comes at a very good time. And with regard to the question that you raised, it is obviously a very broad question that is not easy to answer shortly. And I gave it some thought and I thought, let's take a few steps back and maybe try to add something in terms of, I mean, there's obviously a lot in the briefing already, so I wanted to try and add something with a broader perspective. And I therefore want to start with saying that there's two important principles that I think underlie European fundamental rights protection. On the one hand, the effectiveness principle, and on the other hand, the principle of subsidiarity, to some extent at least. Now, the effectiveness principle can be found in the European Convention on Human Rights, in the preamble, but also, for instance, in the Treaty on the European Union, Articles 2 and 3, I think about, for instance. And this principle of effectiveness means that fundamental rights must be practical and effective. And this has, for instance, allowed the European Court of Human Rights to develop and recognize positive obligations of states to protect convention rights. In many cases, the European Court of Human Rights has accepted that national authorities must effectively ensure that individuals can genuinely and effectively enjoy the rights granted to them. And this is important to remember in the context of statelessness particularly, I think, because the European Convention on Human Rights and the EU Charter of Fundamental Rights do not contain a right to a nationality and do not, or in a limited way, contain socioeconomic rights, which I think are very relevant to addressing statelessness. At the same time, the principle of subsidiarity means that national authorities and courts are primarily responsible for safeguarding fundamental rights, which means that the European courts often leave the specifics of fundamental rights protection to national level, as courts and authorities at the national level are better placed to take into account national sensitivities, societal developments, and national constitutional traditions. And I believe that these two principles can explain some of the jurisprudential evolution of the right to respect for private and family life, as well as inform further litigation on statelessness. It also explains why maybe litigation has only come this far and has not gone further, but it might also help us to think through where to kind of put pressure. I very briefly want to then touch on specific jurisprudential developments, and I think that for the sake of time, I will first stick a little bit with the European Convention on Human Rights. There's two developments that I want to highlight here in particular, and I can say they are also included in the ENS briefing, as you will see. So the European Court of Human Rights has a few decades back already recognized that the denial of citizenship may, under circumstances, raise an issue with regard to private life under Article 8. However, the key case is of a slightly more recent date, which is 2011, the case of Genovese versus Malta, in which the court has recognized that the right to citizenship can fall under the right to private life as it impacts on a person's social identity. And I think this has been very key in terms of being able to bring questions that relate to nationality, as well as the issue of statelessness within the scope and ambit of Article 8 of the right to private life in particular. It has obviously also led to further jurisprudence, in particular relating to various forms of loss and denial of nationality. And it also shows the jurisprudence as it has evolved that there's indeed no right to a particular nationality under the European Convention on Human Rights, which I think can be explained by this principle that I already mentioned, subsidiarity. But at the same time, in view of the practical, effective nature of rights under the Convention, this does not mean that states can do as they please in nationality matters. Nationality matters can certainly be scrutinized by the European Convention on Human Rights and may, in certain circumstances, lead to a violation of Article 8. The other case I want to mention briefly is that of Hoti versus Croatia of 2018, which demonstrated that measures restricting the right to reside in a country may, in certain cases, entail a violation of Article 8 if they create disproportionate repercussions on the private or family life or both of the individuals concerned. And I think this line of jurisprudence may help to break the circle of problems with residence and nationality, be it, if you look at how the court has approached this, be it often only after a very long time of regular residence in a country, which might still be problematic. I'm going to look at Alexia very briefly to see if I have some time to still say a few words about the Charter, the EU Charter of Fundamental Rights, or whether I should leave it at this and save that for the next round.
You have a few minutes, yes.
I have a few more minutes, all right. So I also wanted to turn obviously briefly to the EU Charter of Fundamental Rights, which is of a more recent date than the European Convention on Human Rights. And it should be noted that the development with regard to Article 7, which contains the right to private and family life in the Charter and corresponds with Article 8 of the ECHR, has mostly occurred in cases that concern nationality matters relating to children, such as the Chevis case. The relevance of the notion of EU citizenship, as laid down in Articles 20 and 21 of the Treaty on the Functioning of the European Union, should, however, also be noted in this regard. And I think there is an interesting link there that can also be made with regard to developing jurisprudence around statelessness, where people are left, for instance, unidentified without a legal status for a prolonged period of time. Because building on that jurisprudence and looking at the EU context in particular, where the EU has in fact power to legislate on issues relating to migration, for instance, one might think about reasoning that there is a need for proper identification of stateless people, which might even point to the importance of establishing a common legal framework for identification of statelessness or determination of statelessness within the European Union. And taking that even a step further, one may even wonder whether states could be held accountable for denying those who have a legal status but are unable to take that last step through naturalization to a more certain and full status in the EU as citizens, whether states should be held accountable for that as well. And in view of the concept of EU citizenship as it has developed, taken together with the applicable fundamental rights from the Charter and the EU's role in migration law, there might be reasoning that's possible there as well. I'm going to leave it at this, and I'm very happy to hand back to you, Alexia.
Thank you so much, Kaya. Nuala, building up on that, what do you think is the role of the judiciary in advancing the protection of the human rights of stateless people?
Well, the role of the judiciary is to judge, very simply, and therefore it's not to advance any particular thesis or social progress. Its role is to apply the law. But that said, the role in applying the law is to be sure that as you apply the law, you make sure that you do so in a way that is in conformity with the international standards to which your country has subscribed, and in particular to the standards within the Council of Europe of the European Convention on Human Rights, in the EU to the EU Charter and the other jurisprudence of the CJU that Kaya's already mentioned, and also other international instruments that bind countries, including, for example, the UN Convention on the Rights of the Child. I'm going to save you all having to listen to me talking for a long time, because I'm going to put into the chat, if I can, a reference to, I hope I've put it in, a reference to a recently updated document by the European Court of Human Rights, which takes you through the jurisprudence and the structure of Article 8, the right to respect for family and private life, which are the most relevant ones in the topic we're discussing now. I would refer you in particular to paragraph 95 of that guide, because it's very important, because it tells you when what would appear to be an interference with the right to respect for private life has been adjudged by the court not to be such. You're all familiar with the fact that there is a threshold of severity in relation to Article 3, the prohibition on torture and inhuman and degrading treatment. But it's quite important to look at the cases that are mentioned in paragraph 95 of the guide. That's Basu in Germany, Mohammed in Spain, and Waibal in Switzerland, which look at how you have to decide whether the right to respect for private life has been infringed, and not necessarily violated, whether there has been an interference with it that has to be justified. The whole history of the right to respect for private life, which is the key element for judges to have to litigate, is that if they are not familiar with the case law of the European Court of Human Rights, so I'm mostly talking about national judges here, but occasionally Luxembourg judges, we have to assume that Strasbourg judges are familiar with their own jurisprudence, is the concept of private life because of course originally it was vie privée, because the French don't have a word for privacy, so they use private life to talk about privacy and private life. But the concept of private life has expanded extraordinarily over the last 50, 60 years to include all kinds of other areas of the law, and judges need to be familiar with that, so that if litigators wish to put arguments on behalf of stateless people which are asserting that this is an infringement of the right to respect for private life, then it's important that they understand that this is not just about privacy or the internal sphere, but is about anything which inhibits the possibility to conduct a normal life, interacting with all the other stakeholders with whom they are required to interact on a daily or irregular basis. I just want to add a couple more remarks about family life, because family life is, of course, a partner of private life. It's about the right to develop relationships with a particular group of people, your family. And it's been a great pleasure to work with ENS recently on the intervention we did in the case of Sufi against Greece, which was about the problems that children had in being able to access family reunification proceedings because of the issues surrounding statelessness. And I think that's a very important area, and I see that it's been put in the chat now, the intervention we did in Sufi. So, I mean, somebody mentioned also the Ramadani and the birth registrations in Serbia, which we've also collaborated with ENS on doing interventions in Strasbourg. And that, of course, brings us to the huge importance of the UN Convention on the Rights of the Child, and the importance of ensuring that Article 53 of the European Convention on Human Rights is properly applied, so that there is no construction of an ECHR provision which dilutes the strength and protection which is offered and guaranteed by other international treaties, such as the Statelessness conventions in the countries where they apply, and the UN Convention on the Rights of the Child, which of course applies everywhere except the United States. Alexia, should I stop there and let's move forward?
Thank you, Nuala. Yes, and we can continue the discussion later on in the webinar. Thank you. So I'm turning now to our ENS member with lived experience of statelessness. We know that stateless persons are particularly vulnerable due to the severe impact of statelessness on the enjoyment of fundamental rights. And they are also disproportionately impacted in their ability to enjoy private and family life due to the obstacles that statelessness imposes in their lives, and are often denied rights such as access to employment, education, healthcare, and other civil and political rights. What do you think is the importance of the lived experience and impact of statelessness being better understood by decision makers?
Thank you very much, Alexia. As we heard from our insightful speaker, the right to respect private and family life has enormous potential for advancing the protection of stateless people through litigation. Yet, to truly address statelessness, decision makers must understand the life experience of those affected. Statelessness isn't just a legal term. It represents real struggle such as family torn apart, opportunity lost, dreams differ. It's crucial for judge, policymaker, and legal practitioner to move beyond statistics and see the human lives behind these numbers. Personal stories brings the gravity of statelessness to life, helping those in power craft more informed, compassionate policy to reflect actual needs of these vulnerable communities. When decision makers understand the daily challenges stateless people face, such as being denied access to healthcare, education, and even the most basic legal recognition, it becomes clear that this is more than a legal issue. It's a humanitarian crisis. A key challenge stateless people often face is proving their statelessness in the first place. Many are trapped in cruel cycles, unable to gather the documentation required to prove what the state refused to recognize, leaving them invisible and without rights for many years. The life experience can stir empathy in decision maker, leading to ruling and policy that uphold the dignity, humanity of stateless individuals. Understands these personal stories also may empower the judiciary to make more fair and just decisions, setting precedents that protect the rights of stateless people and pave way for broader systematic change. That's from me. Alexia?
Thank you very much.
Okay, thank you.
Nuala, turning back to you, I don't know if you wanted to add anything to your previous points or if you wanted to react to anything that has been said so far, but to build up on what you said earlier, what would be the recommendations that you would make to litigators, including on how they could use international law to drive systemic change? And also, how could civil society, legal practitioners, and the judiciary better collaborate to advance the protection of stateless people?
Thank you, Alexia, and thank you to the other speakers. I just want to mention one thing here, which is rather controversial, and that eminent doyen of refugee law, Guy Goodwin Gill, would be very upset to know that I was even using these words. And I want to talk about de facto statelessness, because de facto statelessness, sorry, Guy, it occurs when people, although they technically may still have a nationality, are unable to enjoy the benefits associated with that nationality. And I think this has become particularly acute problem in relation to the camps like the Al-Hajj camp in Syria, where the people who went to join ISIS or ISIL are still being held together with children, sometimes children who were born in the camps. And there are enormous difficulties in enabling them to enjoy the private and family life aspects of the nationalities which they technically still have. The French citizens were looked at in the case of HF and France, and in the European Court of Human Rights, which sent the case back to Strasbourg, sent the case back to France to tell them to use a more, a less arbitrary method of deciding which women and which children were able to come back. but also the decisions of the UN Convention on the Rights of the Child, both in relation to Finland and France, about whether or how those children had the right to be brought back to their countries of nationality. In the UK, we have a particularly acute example, which is a young woman called Shamima Begum, who has just about 8 weeks ago lost her final legal challenge in the UK against the deprivation of citizenship. And that was on the basis that the UK government argued that her deprivation of citizenship would not render her stateless, as she had an entitlement to Bangladeshi citizenship. Not that she had Bangladeshi citizenship, but she had an entitlement to it. And of course, we know that the governments of Europe have argued vociferously, including not least the government of the United Kingdom, that the only state that can definitively tell you if somebody has a nationality or not is the state whose nationality is at issue. But of course, in these cases, these people are being denied the possibility of the right to enter under Article 3, Protocol 4 of the European Convention on Human Rights to enter their own countries. And that is a terribly important aspect of the right to respect for family and private life, as well as falling under Article 3 of Protocol 4. And I just think it's important that we think of those acute examples. And there are many, many, many young women and perhaps even more importantly, young children who are caught up in this situation. Thank you.
Thank you, Nuala. And if I can, just react to the term de facto stateless, which, as you say, is problematic. And I see there are quite a lot of discussion in the chat on that. Just to say, the term de facto statelessness is not defined in international law, and so it is recommended to avoid it, because usually it's used to describe a person who should be considered as a national in accordance with a state law, but it's not in practice recognized as a national under the operation of its law. And so typically it's based on a misinterpretation of the definition of statelessness and creates a risk that states will avoid their obligation under international law, so under the 1954 and 1961 conventions, and you've cited relevant examples from that. Thank you, Nuala. Thank you very much. Kaya, what would you say are the current gaps in the protection of stateless people, and how could they be addressed through the regional courts? And please feel free to, if you would like to react to anything that has been said.
Yes, thank you so much, Alexia, and thank you also to the other speakers for their contributions so far. And maybe one of the points that I want to make can help overcome some of the, I mean, I would also be against using the word de facto stateless because of its ambiguousness. And I think one of the things that is still a gap, at least when we look at the protection of stateless people within Europe, is, I think, identification of statelessness in a proper way. And I think by making sure that we are able to identify who is stateless and who is not, and who should be, in fact, recognized as a citizen, we can also overcome this ambiguousness. And I know that's wishful thinking to some extent, but Europe could perhaps take a few steps further there. Identification of statelessness really remains key, because if we look at fundamental rights protection, statelessness may also be a marker for violations of Article 8, as the briefing also clearly shows, but also of other fundamental rights. And even if the principle of subsidiarity that I referred to earlier on does perhaps not allow for stateless determination procedures to be required by courts, because that is not the role that courts tend to have. Identification of statelessness in a broader sense could be something that can be mentioned more broadly and may also put pressure on EU institutions who are able to put in place legislation or policy to enact this relevant legislation and policy. And there's been previous commentators who have done exercises in terms of looking at how the European Union could in fact legislate on statelessness determination. The other thing I briefly wanted to touch upon is something that's been mentioned, I think, previously by my colleague Katja Swider, who I think for ENS actually did a blog on the Hoti case, the Hoti versus Croatia case that I already mentioned briefly before. And she said that in this case, the court, actually the European Court of Human Rights, planted some seedlings of statelessness or stateless migrants being a special category of rights holder under the ECHR. And I think within the ENS briefing, also some of the specifics of the situation of stateless people are mentioned. And I am definitely not all for putting people into boxes, but by having a European Human Rights Court recognize the specifics of statelessness and what it means to be stateless, that kind of categorization and making at least sure that there is an understanding that statelessness is something different from the situation that is faced by other groups, such as asylum seekers or settled migrants, in the context of a human rights court could be an important development, which could hopefully continue towards greater awareness of how statelessness affects the ability to enjoy various fundamental rights. Do I have a bit more time to spend? Because I have one more point that I can make, but I'm also happy to hand the floor back for someone else to comment.
Yes, Kaya, as surprisingly as it may be, we have more time, so please feel free to continue.
All right, thank you so much. So then there's, I guess, one final thing that I actually noticed as I had a bit of privilege to already take a brief look at the ENS briefing as a speaker at this webinar. And this is actually something that I noticed while I was going through this briefing, and I thought this jurisprudence on Article 8 of the European Convention on Human Rights seems to indicate that the connection or ties that a person has to the country that they're in do seem to matter in some way in finding a violation. Stronger ties to a country, such as long-standing residence, family links, etc., appear to increase protection under Article 8, which is probably also very logical when you think about the notions of private life and family life, as Nuala also helpfully illustrated just now. So yeah, this increase in protection might also make it important to think about recognizing that the response may be different. Maybe it's not in certain cases just about ensuring a resident status, but it's also about ensuring a nationality to fully take away the violations of the right to private and or family life. And again, the European Court of Human Rights has been very clear that there's no right to a particular nationality under the convention. But who knows what might happen in the future, and maybe at least they would be inclined to say that actually after long-standing residence, clear ties to a country, never been anywhere else, the situation that is sometimes referred to as statelessness in situ, being stateless in your own country, is not something that should be solved by giving people a residence permit, but should actually be solved by making sure that people can access the nationality of that country. So I'm going to leave that as a little thought with you all, and I'll hand back to Alexia for now.
Thank you so much, Kaya. For our member with lived experience on statelessness, how do you think could lived experience of statelessness be better included? and form an integral part of legal advocacy.
Thank you, Alexia. To better include this life experience of a stateless community in legal advocacy, we must start by integrating personal narrative directly into the legal document. When judges read about the real impact of statelessness, it breathes life into argument presented, making the needs for justice undeniable. Legal practitioners must also receive training that connects them with stateless individuals, allows them to better understand the emotional weight and complexities behind their cases. Collaboration with NGO is essential as these organizations work directly with stateless community and can ensure that advocacy strategy are grounded in real challenges people face. Public awareness campaign can also help bring attention to the human story behind statelessness, building a culture of empathy and understanding that supports legal change. Creating advisory communities that include stateless individuals can further ensure their voice are heard in shaping policy and legal approach. Finally, legal resources such as litigation toolkits should be emphasized how to incorporate life experience into advocacy strategy, enhancing not only effectiveness but also empathy in representing stateless individuals. By centering the voices of those who endure statelessness, we can drive legal change that respect their dignity and rights, making the right to nationality a fundamental reality for all. And maybe I can also add, I can see there's a lot of mention in the de facto stateless. And as I mentioned before, the fundamental struggle for most people in statelessness situation is they cannot find documented evidence to prove that they are in stateless. And sometimes it can be different rules or law between two countries on how they interpret the law. That's it from me. Thanks, Alexia.
Thank you very much. Nuala, please, you have.
Yes, I just wanted to add that I think it's very unlikely that directly asking either national or European courts to acknowledge that it's essential to have a procedure within a country for determining statelessness and in accordance with the statelessness conventions. But I don't think that the courts will be willing to take that step directly. What I think, and this is in answer to the question that I was put by the organizers, I think taking incremental steps using Article 8, the right to respect for private and family life, using Article 3 of Protocol 4, the right to enter a country, and using the jurisprudence on the regularization of the situation of foreigners, then we will come to a state where they will have found that the absence of such a procedure is systematically sustaining a situation where the absence of a procedure for determining statelessness is systematically affecting the private and family life of the individuals concerned, so that it will become only in truly exceptional circumstances that the court will be able to say it's not necessary for there to be a procedure in place. And I think that is the avenue that is more likely to succeed than a more confrontational demand for a process right across the board and across the 46 member states of the Council of Europe. Thank you.
Thank you, Nuala, and thank you all. We received a few questions in the chat, which I am going to go through now. So we have a question in the Denmark context. There has been a proposal to repeal a law that currently allows for the granting of a temporary residence permit to foreign nationals who are unable to return to their country of origin due to practical obstacles beyond their control. This proposal has been sent for consultation, and the person asks whether we have any views on how long this person or such a person could be expected to wait while cooperating as they can before one can argue that there has been an interference or an infringement of their right to private life in Article 8. So not an easy question. Would one of you like to address it?
May I?
Yes.
I think we have already got, and it's mentioned largely in your excellent briefing paper, is that we already have a comprehensive, no, not quite comprehensive, a growing body of jurisprudence in the European Court of Human Rights, which makes it clear that you cannot leave people in a state of limbo where they do not have any status and where they can't exercise their rights. The Baltic state cases are very clear, Smirnova and Sisoyeva, all those cases, very clear that you have to give somebody some kind of status. Now, it's another step to say what the status is that you have to get them. And the court has always insisted it will not prescribe that a particular kind of residence permit is given to anyone, but that a residence permit of some kind has to be given, has been constant jurisprudence for 15 plus years. So I think the problem with Denmark is that they're not complying with the existing body of jurisprudence. The other problem with Denmark is, of course, that they have opted out of many of the EU measures which would contribute towards this. And this whole issue is one that was supposed to be addressed, so it all went a bit pear-shaped, by the returns directive. And the returns directive said you either return people, if you can, in conformity with international law, or you authorize them to stay. You don't have this third opportunity under the returns directive of just leaving people in limbo. Thank you.
Thank you, Nuala. That was super clear. We also had another questions about cuts to legal aid and how that would affect asylum applicants whose asylum claims come under Article 8 and Article 3 of the ECHR. Might be good to address this question also from a statelessness perspective. Would any of you like to address it?
I may not be actually directly answer to the question, but I think the problem with the legal or the terms or the regulation or the policy, there is no flexibility. I mean, because the question talks about asylum, and when you go to the law or policy, it's either you asylum or you fit into statelessness, or you fit to one of the, the legal routes. If you don't fall in that place, in particular for stateless people, it's very difficult. And if you don't have any document evidence, or a state's claim that they can return to the country of origin, while the country of origin say they cannot return. So, and it's just like it's an argument between two countries on their interpretation of the international law, and that can go on for years. And when it's going on for years, the life of the person affected, which is the stateless people, is in limbo, not just in limbo, but it's actually on standstill. They cannot move on. I mean, this is the best I can describe. I mean, from my personal experience, is that I mean, your future is on hold. You can't start a family. You can't move on with a career, your dreams. Everything is on hold. While the person can contribute to the either country of origin or the state they are in, but they can't. I think that's the best I can. It's very difficult to describe, but it just can't. It just stop. There's no forward. You don't even have a future. You can't even look towards for tomorrow. Thank you.
Thank you. I think that was really helpful to put our discussion into perspective. Kaya, I see you want to intervene.
Yeah, maybe I can add on that. Thank you so much for adding that perspective. And I think it is exactly what you mentioned, that your life is on standstill, that influence, that not being able to access the procedures, being on hold, authorities not recognizing who you are, what your status is, that is exactly what interferes with the right to private and family, right to respect for private and family life. And that is, I think, how Article 8 can be brought into also questions that relate to legal aid. If that means that people are left in limbo longer, that can definitely have an impact on people's private life. And it would possibly also involve, obviously, taking on some of the other articles within the European Convention on Human Rights that are about legal aid, that are about effective remedy, etc. But I think there's also maybe something to say with regard to Article 8, and I see Nuala also wants to jump in on that.
Thanks, Kaya. Please, Nuala.
I just wanted to say that it's now over 20 years, it must be over 30 maybe, since the European Court of Human Rights delivered its judgment in the Airy case. And it has singularly failed to address the realities of the assertion of rights. The right to an effective remedy under Article 13 of the Convention is meaningless if people cannot access the remedies. And it's very important that in every case that comes before the court, they not only look at the substantive violations that have occurred, but they look at whether or not the remedies that were theoretically available were in practice accessible, and in practice accessible because there was a possibility to go to court and to litigate. Not Article 6, the right to a fair trial, access to court. We're not talking about that because that very often doesn't apply in the situations we're most concerned about. But Article 13 and the right to an effective remedy, and I think that that's very important.
Thank you very much. We still have a couple of minutes. I don't see any further questions. Would you like to have a final thought? Each of you would love to hear that. Nuala, do you want to start?
Sorry, I'm just reading the chat, which is much more interesting than anything that I might have been going to say. I think that what we have to do is look very carefully at, excuse me, at how we can use the right to respect for family and private life as a tool to open the door in Strasbourg and in Luxembourg to the right to a proper procedure that will determine both whether or not somebody is statelessness, because as your briefing excellently points out, that's absent in a lot of countries, and also the benefits to which stateless people are entitled if they don't have a nationality. And if we have those two elements of the right to respect for private life recognized, then we are only a very short step towards getting the right for stateless people within a particular jurisdiction to have access to a nationality. But my final plea would really be in relation not so much to private life, though it's partly about that, but about family life. And I think the case of Sufi against Greece, which is currently pending before the court, and the case of Ramadani, which is another incidence of problems with the way stateless children are treated, is that countries need to take their obligations under the UN Convention on the Rights of the Child a lot more seriously than they are doing at present. Thank you.
Thank you, Nuala. Kaya, do you want to go next?
Thank you, Alexia, for that. I would want to say that I would want to reiterate, I think, the role that courts can play. I mean, yes, there have been very interesting, forward-looking cases at the courts, and that have resulted in jurisprudence from the courts that was unexpected. I think with regard to statelessness, we are seeing some developments, in particular with regard to the right to respect for private and family life, but we're still waiting, I guess, for that big case that really indeed says something about the importance of identification of statelessness, for instance. Whereas there have been important steps set, and I think building on that, we might be able to get something more out of it, as Nuala has also already helpfully said a few things about. At the same time, the courts are also the courts. In the bigger picture of things, the courts are there to indeed check what states are doing, but they are not there to be there in place of parliaments, of administration, etc. Legislative change needs to come from legislators. So putting pressure on them through the courts is one way to go, but there's obviously other ways in which to try and influence that as well. And I think that is why it's also really important that there's networks like the European Network on Statelessness, who can be directly in touch with policymakers, with legislators, to indeed further understanding on the issue of statelessness. Because I think in this webinar, we've logically very much focused on how to address it legally, but statelessness has a very clear legal dimension, but it's also, I think, a very human problem that is difficult to solve using law alone. And I think making sure that there's input from different sides, including from the courts, remains a key priority as we move forward and try to address statelessness.
Thank you, Kaya. And our ENS member with lived experience, would you like to share a final thought?
Yeah, I just want to echo what Kara said. I mean, she mentioned, some of the things I'd like to say is I believe, there's some step move forward, and I believe that including the life experience and the story behind the actual situation may help the thought to be more empathy and humanized and make a better, fair and just decision. Thank you.
Thank you very much. We are coming to the end of our webinar, and you'll see a feedback survey popping up right now. Thank you very much to our brilliant speakers for this insightful discussion, and thanks to all the participants for your questions, your comments, your attention, and your active participation. So later this week, you'll be able to find a recording of this webinar, as well as the link to our legal briefing on statelessness and the right to respect for private and family life, which we discussed today. You can follow our litigation activities on our website, as well as on our litigation bulletins. Apologies if we were not able to answer all of your questions. Hopefully the legal briefing will answer them, but if you have any further questions which we were not able to answer today, please feel free to email us. Our email address is in the chat and on our website. Thank you again, and I wish you all a great rest of your day.